Welcome back, everyone. The professor here. Today we're going to be looking at copyright. This is the fifth video in our practice topic. I need you to understand this is not to convey legal advice or anything of that nature. If you need counsel, please seek legal counsel. What you are going to get from here is just an architect's point of view of copyright infringement, as I have had some experience with this in my career. This is a topic of called intellectual property IP law and has many facets. In fact, when I was in my undergraduate work, I actually had to take a class. I actually took a class on intellectual property. There were 3 areas in it, but we're only going to focus on copyright because that's really the one that means the most in this particular practice of construction. The other areas of trademark and patents, those really aren't applicable a whole lot, so we won't get into those areas, but we will look at certainly the copyright right now. What designers want is to protect their intellectual property. They want to get paid for reuse of plans. They want to have control of these instruments of service. That's what those documents are. We'll get into that momentarily. Owners, on the other hand, they want to be able to use designs without fear of having to pay additional royalties, infringement claims. They want to be able sometimes to kind of publish the drawings or even pictures of it. Sometimes they like to use the word in their contract, ownership of the drawings. Not sure what that necessarily means, but we're going to try to clear some of that up in the intent of this video. But herein lies the tug of war, and it starts. Designers want to preserve their rights, but owners want to be able to avoid unexpected costs in the future. It used to be that we could only copyright the drawings themselves. In about 1991, the copyright laws were rewritten, which not only helped us do a lot of protection of our own intellectual property on the design side, but it also opened up for the first time copywriting architecture. We're going to get into all that here a little later as we go into this video. So here's the question. What does the client really purchase with these instruments of services provided by professional services? In a single word, knowledge. Is knowledge, specialized knowledge in training, experience that allows us to develop these designs. And that's really what the client is wanting to get into. This is what we call intellectual property, or IP. It's owned exclusively by the developer of the IP. It's also known as copyright, as seen with that little C with the circle around it. Anytime you see that, that tells you that is a copyrighted work. So IP rights do not transfer from the developer or the owner of the intellectual property without specific conveyance, i.e. a contract. Those rights just can't be transferred through an implied approach. It has to explicitly be done through a contract. Plans, specification, reports, and other professional documents are developed for a specific project on a specific site. The use of those documents for that project, for that site, is what is referred to as an implied license to the client for this single use. You're not required to have to put that copyright notice, but it is advisable to put it on. If you have to go into court, having that on each sheet of the drawings in the title block, having it on the cover sheet of the specifications or the title sheet of the report, all very helpful should you have to go to court for it. What type of things can be copyrighted? Well, first of all, as we just spoke about, the drawings traditionally was always capable of being copyrighted. And since 1991, architecture now can be copyrighted. All new work. If you're creating a brand new work, ground up, what we call in the field, that will be copyrighted directly to you as the developer 100%. Derivative work. Well, what is derivative work? If you have an existing building and you do an addition or you do a renovation to it, that would be a derivative work. The original work copyright will be maintained by the original of that work, and that's why you have to be aware of that, especially if you get ready to go ahead and register that with the Copyright Office. You would have to register it as a derivative work because there was an existing work that was done by someone else. This also applies to drawings. So if you have drawings and you add to it or something of that nature, this would be the same thing. Again, the derivative work would still be applicable to it. Registering the copyright is not required to develop your rights since 1991. However, you need to have it registered before you go to court. If someone infringes on your rights, the first thing you want to do is go register it. It doesn't take a whole lot to do at the Copyright Office. It'll be as little as $50 to a little over $100, depending on what exactly you're copywriting and at the time what the Copyright Office has. Registering of drawings and architecture may require separate permits. In other words, you may have to file one permit for the drawings and a second permit for the architecture if you so do it. Please remember, when you do this, keep in mind if it's a derivative work, if it's an addition. Transfer of the electronic medium is not covered by copyright law, so you must negotiate that independently. As an owner, don't just assume you're going to get electronics from it, even if you want to use it for facilities management or whatever. You're still going to have to negotiate that separately and also transfer those rights, or at least a license to use it. Always verify the release when you are given electronic data. If a client gives you a disk, gives you access to files that you download, you need to go back, because ultimately, if rights haven't been given to that client to give you this, you could be caught up in the middle of a potential infringement. It's easier, just always go back to the original. As a professional, if you've got someone comes to you and say, hey, we want to use this, professional courtesy, treat them fairly. I've had sometimes where a client wants to use some existing drawings, but then the other architect it gets a little more of a pain in the butt and makes it real hard to reuse those drawings. That's not a really good professional thing. You'll get a reputation and clients won't want to deal with you. Single use of these instruments are not always the case. A home builder, they oftentimes will develop a standard plan, and then they're going to use that standard plan, and we need to understand that that's a special case and it's always negotiated. Typically, when I was in the production homes, we would develop a standard plan. When we developed the standard plan, the client would pay for that, but then when they get ready to use it in a subdivision, there would be a reuse fee. We get all the engineers to do the same thing with theirs. They'd probably get reuse fees, and then you could use it on that subdivision, and if you roll that plan to another one, so on and so forth. That's something you always need to remember, because having those plans and reusing those plans is not an implied or an intrinsic right that the owner has when they buy these plans or when they purchase these professional services. Problems are usually created when these instruments or services are used on another project without permission. I've been in the middle of that where a couple times. I'll get into that in a minute. When someone does this and use these plans, these documents, these copyrighted documents without permission, this is called copyright infringement. Here's the caveat. This is a federal crime. It could carry up to $150,000 and or 5 years in jail per infringement action. So you start to see that can be really dicey. If you copyright the drawings, every sheet could be seen as an infringement. So you start to see how this can become quite a significant issue. Continuing on, the thing with potential problems, you need to understand there is a statute of limitation of 3 years. In other words, once the infringement is known, you have 3 years to act on it. You go beyond the 3 years, you won't have any rights to enforce that. So you usually want to be really careful about that. in order to take copyright action, the infringer's access to the original work has to be established. You have to show that the infringer had access to those drawings. That in and of itself can be a task. You may not be capable of showing, oh, they had access to these plans, they saw that particular work. So that's really kind of one of the little hurdles you have to go about. However, in this electronic world that we've got, it's a lot easier, because if you can get a hold of those electronic files and you start looking in it, layer naming conventions, block naming conventions, family types in a BIM model, they all can leave fingerprints behind that. An advanced CAD operator or BIM modeler can actually isolate and say, oh, hey, that is our work. Once you do that, then you have to be able to trace, how did they get that particular file? Was it passed by client? Again, always having to show that the copyright, the infringer had access to the original work. It's not like a patent. When you have a patent, you don't have to have access to it. If you do something, even if you did it independently and you got something that's substantially the same as the patent holder, you could be in trouble for that infringement on the patent. So it's a little different with patents than it is with copyright, but that's one of the reasons you always want to be diligent about your intellectual property. So a couple examples. I've seen this done in my career where back in the old days before we had the computers, someone, an architect would take a drawing from another architect and literally slice off their title block, put their title block on, and reuse the plans. That is technically a copyright infringement. Sometimes I had one client take one of my drawings, and they actually took the project. They changed just the name of the project and resubmit the whole thing. The only reason I knew about it is that particular project was submitted to a local jurisdiction where I had already used that project relatively recent, and the plan reviewer happened to know who I was and gave me a call and said, hey, did you submit these other plans? Because there were some inconsistencies. And right away I said, absolutely not. And at that point, I had the opportunity to go back to the jurisdiction and invoke my copyright, and I shut the whole project down. Ultimately, it led to an action with the registrar of contractors, with the home builder, who did face penalty, and ultimately ended up going out of business. That's a big step, but that was something, and I never followed through at the federal level with the copyright infringement, although I could have, but there was absolutely no reason to, because it was taking years to get anything, and by the time the business closed up, there was no resources anyway. The big thing is using Cad and Bim files. You get a client, they send you, oh, here's a floor plan, or here's the model for this particular project. Using that without getting some sort of release could actually bring you into the middle of it. So you want to be very, very careful, especially in this day and age, because models, whether it's a CAD drawing or whether it's a BIM drawing, a lot of those models don't have title blocks tied to them, depending on the particular software you've got. If they're not, because it could be in by XREF or something that's attached by reference there, but doesn't have to be there when they give it to you. You want to be very careful about using that, because you just don't want to get into the middle of it. Besides, it's just bad professional ethics to do that and have to square off with another professional because you essentially stole their work. Really smart to watch that when clients give you files or want you to use drawings. Do your own due diligence so you don't put something out there hanging and end up with some sort of a liability you're unknown of. That's the big thing with the copyright. Always incorporate the full set drawings and plans and specifications into the contractor's agreement. In other words, in the early part of it, they'll reference sheet by sheet, the sheet number, the name, the date that it was published, all that stuff. Make sure that goes into it. See, we call them construction documents, quote unquote, but really, when I first started, we always called them contract documents. And the reason why we called them that is the contract would be having these as an amendment or an exhibit to. So You want to make sure that always happens. The other thing is, by having that, there's always that trace that that contract could show that this person had access for when you do some sort of an infringement action. When the intent is to transfer copyright, we use the work for hire. In other words, don't use work for hire unless you intend to pass and give up all your intellectual property rights for that particular work. Understand, employees cannot develop their own IP rights when working for a company unless there's some sort of an agreement. Sometimes they do, sometimes they don't. But really, when you're working for a company, you can't develop those rights, generally speaking. Same thing as a designer. When a client comes to you, there's no implied access to that copyright. But if you put in the agreement as work for hire, you literally have moved yourself to an employee of that particular client when it comes to evaluating copyright law. So you want to be very careful when you use anything even remotely similar to work for hire. That's why you always want to seek your counsel. Sometimes we look at the implications of this, and we need to be very, very aware of what those implications are, because we may inadvertently be passing our rights off without knowing it. We don't want to say work for hire. Owners want to sit there and say we want to have ownership of the drawings. You need to understand what that means. Like I said, when they address ownership of drawings, we really, it gets real muddy as to, are you actually passing your rights or whatever. Try to define that. Most owners, like cities, they will actually keep copies of the plans. They'll put it up on a website, or they'll keep it in their files, and someone can go get a copy of it. The owners want to use that, don't want to get hit up with copyright infringement on such uses like that. So being aware of that becomes very, very valuable in my operations and my agreements with the client. It makes it very, very palatable to the owner if I let them know, hey, this is what we're doing. Now, I know this was a real quick topic. It was real easy, real short. But I did write an article on it, as many of these you do. So click on the link below. You get to read the article. I've got a lot more in detail in some of this stuff that I didn't get into in this short little video. But I think you'll find it all very interesting. If you find this video helpful and you like to learn something from it, please be sure to like this video, subscribe to the channel. Be sure to click on that little bell so you get a notification every time a new video is uploaded. And remember, design well, build safe, be sure to maintain our buildings for longer life. Remember, until the next time, the professor out.